Illinois will become the first state in the nation to eliminate cash bail. The state Supreme Court ruling the Constitution does not mandate monetary bail as the only way to ensure criminal defendants appear for trial, nor the only means to protect the public. This goes into effect in mid-September. An investigative reporter, Ben Bradley from our Chicago station, joins me here on set. Always great to see you, Ben. We've talked about this before, so we knew this was coming, but why Illinois? Why Chicago specifically? Everybody, of course, always thinks of Chicago.
You make a good point. It comes at a very tumultuous time in terms of public safety here in Chicago. But this new law affects the entire state of Illinois. But if we just focus on Chicago, murders, shootings down this year 7% compared to last year, down 20% compared to 2 years ago, but still above where they were before the pandemic. So you have a lot of people very concerned about safety, feeling like police don't have the tools they need. Now you go to this system that they've already been experimenting with here in Cook County, where cash and your ability to raise it and post it is not the determining factor on whether or not you're able to get out of jail while you await trial. They point to studies that say it doesn't make a place less safe. New Jersey has also experimented with this. But this is the first time it's been done on a statewide level. And you better believe that there's a lot of prosecutors downstate who are not happy and fought this.
And I want to talk to you about some of the reaction to this. Before we get to that, you talked about murders. Now, you cited some stats there. What is the metric for success in this? What is the timeline going to be to know, hey, if this is working or it's not?
So the ultimate metric, I guess you would say, is safety. At the end of, say, 2 years, pick your timeline, is Illinois more or less safe than it was before they instituted it? But proponents of this elimination of cash bail will say there are a lot of metrics that are far more difficult to quantify. Things like, if a person is in jail awaiting trial for 8 months for, burglary or something like that, couldn't post bond, that's disruptive to their own life, that's disruptive to their family, they're unable to hold a job, which creates all sorts of additional societal problems. So the point of this is to say, hey, can we keep people who we don't think are dangerous, still circulating in public, still in theory being productive citizens while they await trial.
Right. And so it's certainly not difficult to understand what the criticism would be to this. So we'll just take the politicians out of it. What are people saying? How are people reacting? How are judges reacting who will have to now impose this?
So in the end, the Illinois State Supreme Court are the final judges, and they said this is constitutional. I should say the Illinois Supreme Court is heavily stocked with Democrats. Having said that, we did hear from the majority of state's attorneys throughout Illinois when this Safety Act, as it's known, was first proposed, and they had significant concerns. But I talked with a Republican state's attorney in DuPage County, which is just west of the city of Chicago. He was on a committee where they tweaked the law after it was passed to address some of those concerns. He says, it's not perfect. There are still some situations where we worry potentially violent people will be able to get out of jail while awaiting trial. But he thinks in a lot of the circumstances, they have been able to adjust the law to satisfy critics somewhere along the line.
Yeah, we'll certainly see what happens here. No easy answers. Always great to speak to you, Ben Bradley from our Chicago station. Thank you for watching. Go to newsnationnow.com to find News Nation on your television provider. And don't forget to click the red subscribe button below to get more of News Nation's fact-driven, unbiased coverage.